Hello, I'm Alexander Haberbush, president of the Lex Rex Institute and a constitutional attorney. And as always, nothing in this video constitutes legal advice. So today I'm going to be doing yet another video in our series entitled Ask an Attorney, where I answer unscripted questions from you, the community, about matters related to constitutional law or related legal areas. If you have any legal question, go ahead and post that in our comments on this video, or you can comment on our Facebook page or on our website or by email. Heck, you can mail them in, Pony Express, whatever you want. If you send those questions in, we'll probably get them and we will answer them. These videos are going to be posted on Friday afternoons, as I've mentioned. Our last one was actually posted on a Monday because of a whole controversy that we had with YouTube over what they alleged to be misinformation about the 2020 election in some of our YouTube videos. So they suspended us from posting for about a week, I think. Those videos have since been restored, so I guess they are now saying those did not contain misinformation. Go figure. But I'm not going to get too much into that today. If you want to read about that, you can go on our website, lexrex.org, and we've got plenty of information about that there. So today I'm going to be answering a question about constitutional law, and let me see if I can pull that up. Let's see. There we go. Okay, in what circumstances, if any, would eminent domain be properly implemented? Oh boy, that's a really complicated question. There's a number of ways that I can go about answering that. Well, let's just start by talking about what the phrase eminent domain means. So eminent domain is derived from Latin, I believe from dominium eminens or something like that. My Latin's not very good. But a phrase meaning supreme lordship. And it's used mostly in a European context, continental European context, less than an English context. I think it was actually originated by a Dutch legal scholar in the 17th century. But what that refers to is the idea that the sovereign is the ultimate owner of land. That any title, any freehold title that copyhold title, any title that a person holds during their life, or even one that is heritable, one they can give to their heirs, is one that is ultimately a grant from the king, and that under certain conditions it can revert to the king because he is the supreme lord over the land. We don't have that in America, and actually they didn't even have that in pre-American England. Instead, what we have is every American has an absolute right to land ownership. You are the ultimate lord of your land. That's why we call landlords landlords, actually. It's because they're the one that has ultimate control over that land. And under no circumstances does the government have a superior claim to that land, because as we remember, in the United States, our government is a government derived from the people. The legislature are people that we appoint to act in our stead and on our behalf as sort of trustees or agents to do things that they think we would want them to do, or at the very least are in our interests. So they're exercising our rights when they do that. They do not have a superior claim to anything. So I would just as soon not use the phrase eminent domain when referring to government takings of land. But when referring to proper eminent domain, you're meaning superior lordship over land, I would say proper use of eminent domain is all the time by everybody who owns land. They have eminent domain over it, and that's great. That's probably not what the person who asked this question meant. They were probably referring to government seizure of land. So let me get into that as well. In an Anglo-American context, in a common law context, that's usually referred to as condemnation. The land is condemned when it is taken by the government for some kind of public use or for the use of the crown or what have you. So just as, a prisoner is condemned when, or I guess somebody accused is condemned when they are sentenced because they are going to be deprived of various liberties they previously held, property is condemned when the person who had property rights over that land no longer has those property rights. So we refer to land as being condemned when it's land the government has stated it's going to acquire. Okay, so under what circumstances can the government condemn land then? Well, I'm going to pull up an excerpt from William Blackstone. William Blackstone is certainly the founder's primary authority on law. He wrote an entire long series of several volume set called Commentaries on the Laws of England that summarized the common law jurisprudence that had evolved up to that point in history. And he wrote, I think the first edition came out in the mid-1750s. So he was writing pretty much contemporary with the Founding Fathers. And as we know, the common law that Blackstone was writing about was that continued to remain in effect in the States after they had separated from England. So that common law was still in effect. It's actually still in effect today. There have been legislative modifications in many states, as well as clarifications by common law judges, just regular court judges. But that common law system is still in effect. So what Blackstone says had an incredibly profound effect upon the Founding Fathers, and it still really, in a lot of cases, summarizes the way that our law works today. So here's what he has to say about the right to property. Let me enable this display. So he says, "So great, moreover, is the regard of the law for private property that it will not authorize the least violation of it. No, not even for the general good of the whole community. If a new road, for instance, were to be made through the grounds of a private person, it might perhaps be extensively beneficial to the public, but the law permits no man or set of men to do this without consent of the owner of the land." So again, property is one of the most significant, most important rights that Blackstone recognizes, and it's essentially inviolable. He does give one exception to this, and he says it's right here. Where property is taken. So, okay, besides the public good, is in nothing more essentially interested than in the protection of every individual's private rights, as modeled by the municipal law. And then referring to the municipal law, he says, in this and similar cases, the legislature alone can and indeed frequently does interpose and compel the individual to acquiesce. And then he goes on to say, but they don't do this lightly. They only do it very rarely. And importantly, the legislature is the only one who can do it. Well, why is that? That's for the reason that I mentioned a few moments ago. Let me close this. That's for the reason that I mentioned a few moments ago. The legislature is essentially the appointed representative of the people in government, so it is acting on the people's behalf when it does act. So, what kind of conditions need to be in effect when the legislature takes somebody of their land? Well, Blackstone says not by absolutely stripping the subject of his property in an arbitrary manner, but by giving him a full indemnification equivalent for the injury thereby sustained. That's a fancy way of saying that the government has to pay the fair value of the price that it is confiscating. I'm sorry, the fair value of the property that it is confiscating. And, it says possessions at a reasonable price, and it's an indulgence the legislature exercises with caution. So these are the conditions that Blackstone says exist. When he is writing, these conditions already exist and are in place if the government wants to confiscate someone's land. So these are the conditions that end up being carried effect into the United States of America as well, in each of the states if they want to confiscate private property. So why is there then a clause of our Fifth Amendment that says that takings of private property, so this is, just so that you're aware, this is what's often used to, when talking about the idea of taking private property, is people make recourse to the Fifth Amendment of the Constitution. And specifically, they look at the very last clause in that amendment, which refers to takings of private property. And on that subject, the Fifth Amendment says that takings of private property have to be given just compensation, and that it must be for the public use. In other words, that property must be seized for the public use. And those are the conditions put upon the taking of private property. Well, why does the Constitution bother saying this if, as we know from Blackstone, that right already existed under the law that was in effect in every state in the Union? Well, there was a group called the Anti-Federalists, which you probably heard about in history class, if nowhere else, who was very concerned that the federal Constitution that was proposed in 1787 was one that would gradually erode some of those rights that have been recognized for a long, long time under English and American law. So they wanted to include protections saying that, just in case it's not clear from the rest of the Constitution, here's the things that we don't think that you're allowed to do. And one of those things listed in the Fifth Amendment is taking private property without just compensation or for a purpose other than public use. Now, at this point, it's probably appropriate to talk about the distinction between state and federal power. As originally conceived, the Bill of Rights, as I mentioned, was a limitation on the federal Constitution. The federal Constitution was the empowering document for the federal government. So the Bill of Rights applied for the most part, there are some exceptions here and there, but for the most part against the federal government. And that's true of the Takings Clause of the Fifth Amendment as well. So at this point, we're going to talk separately about the federal power to seize property versus the state power to seize property. We're going to focus on, we've already sort of covered the state, so if the state's not covered under the Fifth Amendment, at least as originally understood, it does end up being incorporated under the 14th Amendment, but we'll get to that in a bit. But as originally understood, that restriction applied only to the federal government, so that's what we have in the Fifth Amendment. Now, people are kind of sloppy when they talk about this, I've found, in large part, because people tend to refer to the Takings Clause of the Fifth Amendment as though it authorizes Congress to be able to take people's property for public use. That is not true. As we know of the rest of the Bill of Rights are limitations on the exercise of power. They're limitations on what powers Congress can exercise. Or, to be even clearer, they are clarifications of what limitations Congress already has on its power. So if the Fifth Amendment is saying the conditions in which Congress is limited to taking away people's private property, what empowers the federal government to take private property? In order to limit that power, you have to see that there's a presumption that power must already exist. If you tell somebody you can only take your property under these circumstances, that presumes that they're able to take property at all. So as we know, the Constitution is a constitution of enumerated powers. The only powers that Congress has are the ones that are explicitly mentioned in the Constitution or that can be validly inferred to bring into effect those other powers, which we call necessary and proper, and we'll get to that in a bit too. But it's got to be mentioned somewhere in the Constitution that Congress has the power to take private property. So I'm going to share my screen again. This time we're looking at Article 1, Section 8 of the U.S. Constitution, beginning here. So it begins pretty close to the top of the page, goes through this page, down through the next page, and ends pretty close to the bottom, or actually right at the bottom of this page. So the entire Article 1, Section 8 of the Constitution is about a page and maybe 3/4 if you're being pretty generous. And these are all of the powers that Congress has. There are 18 of them. This is pretty wide margins and it's pretty large text, and there's a lot of hard enters in this, so it's not that much text, only 18 powers. These are things like borrowing money on credit, regulating commerce. I guess this doesn't highlight things. Oh, no, it does. Okay. Establish uniform rule of naturalization, coin money, establish post offices, promote progressive arts and sciences and useful arts. A lot of these things, I don't see anything in these that authorizes the federal government to seize private lands. I don't know if you do. Read through them, see if you see anything there, but I certainly don't. So if it's not found in Article 1, Section 8, which lists all the powers of Congress, then where the heck would it be in the Constitution? And that's the question. Now, I just want to get one thing out of the way real quick. There's another clause of the Constitution called the Enclaves Clause, which does empower Congress to exercise jurisdiction over places that they have purchased with the consent of the legislatures of the states. So state lands that they've purchased with the consent of those states' legislatures. And that's for the use of, I think this Constitution says, forts, magazines, arsenals, dockyards, and other needful buildings. But what that clause significantly says is that it allows the federal government to exercise jurisdiction. Or I think the word that it uses is actually authority. But what that word refers to is jurisdictional authority over those lands, not to title over those lands. Well, what's the difference? Well, title is, as we know, what gives you a right of ownership over something. Jurisdiction is basically the right to enforce rules over that territory. So in order for Congress to take land from a state and then exercise jurisdiction over it, it needs to get the consent of that state's legislature, which makes total sense because states are sovereign over their own land. If they're going to cede that sovereignty to somebody else, they have to say that they're doing it. And they have to agree to do it. So some people have used that as sort of a congressional justification for the takings of private property, but I just don't think that works because that has nothing to do with title over property. So if it's not found in Article 1, Section 8 of the Constitution, then it's not found elsewhere in the Constitution, then where is it? And, for a long, long time, for a lot of our country's history, first probably about 90 years of our country's history, that power was commonly believed, widely believed, to be nowhere in the federal Constitution. Essentially, the Fifth Amendment was protecting against something that could never happen because the federal government could never take people's property without the consent of the states. Now, how did that work, practically speaking, in our early republic? Well, prior to the Civil War, when federal government wanted to acquire land, what it had to do was it had to essentially cooperate with the state governments to do that. So they could either ask a state legislature to use their right to condemn property, and then the state legislature would transfer that property to the federal government, or, and this was probably the more common way they would exercise it, they could send federal agents who would then act as plaintiffs under state law to acquire that property. Well, how did that work? Well, for instance, Massachusetts had a law in place that said that a federal agent could appeal to a tribunal of disinterested people that state would appoint when they wanted to take private property, and then that tribunal would basically act as a delegate of the legislature, so somebody the legislature had empowered to make that decision. So that would effectively still be a decision of the legislature of that state when they wanted to condemn property. And it's not just that the government did less, or federal government did less when it came to taking private property in the years before the Civil War. I mean, that argument's commonly made. Well, our government did a whole lot less back in the day, so they didn't need to be able to confiscate private property yet, and it just must not have come up often enough that they had to do it, even though they technically had the power. That's actually not true. Even as early as Thomas Jefferson's presidency, we were working on a national road project. And there's actually correspondence from Thomas Jefferson complaining about how he has to coordinate between all these different states in order to complete the federal road. But he does do it. He manages to get a road completed by using exclusively state authority to seize private property. Now, roads are kind of the common example that are used for the validity of government use of eminent domain, or of taking, or condemnation, whatever you want to call it, because roads have to be contiguous. You can't have sections where 20 people in a row might want to sell, but if the 21st guy says, nah, I don't want to sell, well, you can't just have your road stop there. It has to keep going. So you need to be able to purchase specific pieces of property, and that's often where these conflicts arise. Because if somebody is willing to sell their property at a fair market price, you don't even get to the question of whether or not government can validly take it, because they don't have to take it. They just purchase it. So anyway, that's all to say, we really don't get any authority saying federal government can exercise the power to take property until after the Civil War. In fact, in 1845, there's a decision. It's Pollard's-Lessee versus Pollard's-Lessee versus Hagen, which explicitly holds that the federal government does not have the power to exercise eminent domain over state land. Now, after the Civil War, in a case that took place in 1878, it's Cole v. United States. It's kind of the seminal case on takings clause in terms of empowering the federal government to exercise the power to take property, says that the necessary and proper clause is where we find the congressional power to take private property. Well, what's the necessary and proper clause? Well, let's turn back to that copy of the Constitution we were looking at a bit ago. And here we've got, here's the Enclaves Clause, by the way, so that's also in Article 1, Section 8. And here we've got, to make laws which shall be necessary and proper for carrying into execution the foregoing powers. So right there, necessary and proper. This is the necessary and proper clause. And what it essentially says is that if it's necessary for Congress to exercise a particular power in order to carry into effect one of the powers mentioned in the rest of Article 1, Section 8, then Congress has that power as well. Now, this, again, traces back to a concept we alluded to briefly earlier, which is the idea of British agency law, English common law agency law, which carries over into the States as well, which basically says that agents, when they act on behalf of somebody else, do so only with the power that is delegated to them by the person who originally possesses that power. That probably sounds very complicated. It's actually very, very simple. So think about it this way. If you're going on vacation and you hire your friend to take care of your house while you're gone, let's turn this off. You hire your friend to take care of your house while you're gone. And you tell him, here's the different things I want you to do. I want you to make sure the lights stay on at night so that some people know that there's somebody occupying the house and doesn't get robbed. I want you to mow the lawn so that it stays in good shape while I'm gone. I want you to, maintain the, well, you probably wouldn't want a friend to repaint your house while you were gone, but I want you to do general maintenance kind of stuff, maybe dusting things or here and there. Just watch the house while I'm gone. And then you leave. Well, your friend is left there, and they have to decide which powers they validly possess and which ones they do not. So they wake up one day and they notice the lawn's getting a little bit long. You said you're supposed to mow the lawn once a week while you're on vacation. So they figure, I've got to mow the lawn. I know that you have a lawnmower in your garage, so I'm going to grab that lawnmower and I'm going to mow the lawn. We would say that the power to use your lawnmower is a power that is necessary and proper for carrying into effect what we know that person's duty is, i.e. mowing the lawn. You need a lawnmower to mow the lawn, so it's necessary and proper to carry into effect that task by using your lawnmower. That makes complete sense, right? We would probably not say that your friend had a right to sell your house, even if he gets a really good offer. If somebody comes up and says, I'm going to offer you $1 million for this house. We know the market value is only about $500,000. Even though it's a really good offer, that's just not within the power that you've delegated to him, because that's not the sort of thing that you expect somebody to do when you ask them to watch your house. So that's sort of the route that jurisprudence on this necessary and proper clause takes. It says that something is necessary and proper to carrying into effect another power if there's no way they could do that power without exercising this additional power that is implied. And we call those powers implied powers of Congress, and those are valid. As originalists, we can still think that Congress has implied powers. We would just be very strict about whether or not something is actually necessary to carry into effect another power. And what the court ends up saying in the 1875 case, Cole v. United States, is that the power to seize private property, to take private property with just compensation, is necessary and proper to carry into effect things like building post offices or making roads, things which are mentioned as congressional powers in Article 1, Section 8. Well, is that true? If you listen to what I said earlier, I don't think that is true, because the government was already doing that. Federal government was already negotiating with states to accomplish those things. So I think the argument that it actually is necessary and proper to carry into effect making post offices just isn't true. It doesn't hold water, because there's other ways for the federal government to do this. Now, what if states won't cooperate when the federal government tries to purchase land? Well, that's a separate issue, and I think that's probably beyond the purview of this video, but it is something to think about and something we can address in a future video if any of you guys are interested in hearing that. But that 1875 case, sort of the seminal case on federal power with respect to the taking of private property. So after that case, it is recognized that both federal and state governments can take private property for public use. Another significant case is Usv Gettysburg Electric, I think it's Gettysburg Electric Railway Company. And that's an 1896 case, I believe. And what that case does is it incorporates to the states under the 14th Amendment, doctrine of selective incorporation, which is under the Equal Protection Clause of the 14th Amendment. I talked about that a bit more in last week's video, our Second Amendment video on, I think, constitutional carry states was what that question asked about. But basically what it means when something's incorporated to the states is that what previously in the Bill of Rights only applied against the federal government begins to apply against the states as well. So the limitation that property can only be taken with just compensation and only for the public use now applies to the states as well. As I mentioned, they already were basically bound by that because of what William Blackstone says already existed under the English common law, but now they're explicitly bound by the actual text of the Takings Clause of the Fifth Amendment. So now that we know, both federal and state government currently are allowed to take private property, whether or not that's the correct constitutional interpretation, I think is up for grabs. But that's where the law currently stands on this. So they can both do it. They can both take private property. So I think now is where it's appropriate to look to the actual text of when they are allowed to do that, keeping in mind that any constitutional provision is sort of the outermost limit of what government can do. State governments are absolutely empowered to make restrictions on the seizure of private property, the condemnation of private property in excess of what the Fifth Amendment says. But this is the bare minimum for the protections that both states and federal government have to offer when taking private property. So the important words in the Takings Clause are going to be public and use. Now, in interpreting text of the Constitution, we look first at sort of the plain meaning of that text. But when the plain meaning of a text is ambiguous, you look at the way that a reasonably sophisticated person reading it in 1787 would have understood it, because that's how we know what the Constitution means, is people it was actually addressed to. You know, the state delegations that were supposed to be approving the Constitution, the very people who were supposed to read it, how would they have understood it when they were looking at it? So this is a quotation from Samuel Johnson's Dictionary of the English Language. This was published in 1786, so the year before the Constitutional Convention, would have been very contemporary at the time. And that defined the word public as belonging to a state or nation, i.e. not private. So we use public a lot of ways nowadays, right? We could take public to mean, like we say somebody does something in public when they're under everybody's eye, when everybody can see them. They're not hiding it. But the definition of public was actually a bit more specific than that, as it would have been used in a constitutional context. There, it specifically meant belonging to a state or nation. So for something to be public, it has to be something that is not held in a private person's hands. It has to be in the hands of the state. Well, let's look at the next word that is used, which ironically is the word use. Well, Samuel Johnson's dictionary defines that as the act of employing anything to a particular purpose. That's what it means to use something. So what does that mean about when government can take lands? Public use. So that belonging to a state or nation, not private. When the act of employing that thing, to any purpose. So the act of employing the property seized to a purpose belonging to the state, not to a private person. So what does the subsequent case law on this look like, and does it end up respecting that? I'll let you be the judge of that, but I think you're probably going to be able to ascertain my opinion on that. So in 1984, we have the Hawaii Housing Authority v. Midkiff case. And what that case does is so in Hawaii at the time, on the island of Oahu, I believe about 72% of the land is owned by about 20 people. A lot of this is a carryover from the Hawaiian royal family, so a lot of the land's owned in trust by various entities after that point. And Hawaii institutes a law to essentially force the owners of this private owners of this Hawaiian property to give it to other private individuals, specifically people who are currently renting homes or leasing land on the island of Oahu, saying, we should make them owners of the land, because with 72% owned by 20 people, there's just no way anybody can ever become a landowner here. So we got to redistribute it. The state of Hawaii institutes this law. And this law gets challenged, and it goes to the Supreme Court. And the argument against this Hawaiian law is, I'm sure that by this point you can anticipate it, giving land from one person to another is not public use, that's private use. Well, what the court ends up saying in that case is that there is a sufficient public interest in making sure that these other people, these private citizens, own land on Hawaii, that it can constitute public use. And they essentially shift the goalposts a bit and change what ought to be public use to, in my opinion, meaning public necessity. So they're saying, it's necessary, it's really a good idea for the public to have this, therefore it's okay for us to confiscate this property and to give it to other people. Well, that's not the language used in the Constitution, and significantly, that's why I had you take a look at that section from Blackstone. As Blackstone explicitly says, there is no necessity that is sufficient to alienate somebody's right to private property, because the public interest is always in that right of private property being maintained, because private property is such a significant right. Therefore, there is never a public necessity to confiscate private property. So this sort of eliding between public use and public necessity that the court engages in the Hawaii Housing Authority case, I think is just totally inappropriate. You can be the judge of that, whether or not that is valid. Oh, and by the way, I should have mentioned this earlier, but James Madison uses almost the exact same language as Blackstone in his private correspondence. He's sort of, by many, regarded to be the principal author of the Constitution. And he actually calls property to be the entire purpose for which government exists, is to protect private property. So if that's the reason the government exists, how could you possibly have a public necessity that is more compelling than maintaining that right of private property? You just can't. That right of private property is basic to what the government is. Founding fathers all understood that. So this public use provision of the Fifth Amendment, I think, is extremely significant to its interpretation because, again, under agency law, as we mentioned earlier, legislators act as the delegates or the agents of the people, so they are acting on our behalf when they take that property for public use. In other words, the person who gave up the property is still getting to use it because it's now public, it's in public hands, as opposed to taking it and giving it to another private party, which is just theft. That there's really no two ways about that, in my view. If you're taking property and giving it to somebody else, that is theft. Even if you're giving them just compensation. if a thief comes and takes your car and then gives you the fair market value of the car, places that on the curb next to it, and you come and pick up that money, you're still going to say my car is stolen. I think anybody would say that. So I don't know that there's a plausible argument that taking for other private entities is within the purview of what the Fifth Amendment allows. So that's the Hawaii Housing Authority case. And then after the Hawaii Housing Authority case, we have the Kelo decision, which is sort of that's where we currently are when it comes to public takings of private property. And what the Kelo decision pertained to was a case in which the state government was attempting to seize lands essentially for an economic redevelopment project to improve the land. It was land that was run down and dilapidated, debatably, and they wanted to improve it. And this land was across the street, get this, from a facility owned by Pfizer. It was going to be developed to essentially be a retail shopping area that would be in use by Pfizer employees and exist principally for the benefit of Pfizer. And the argument that there's actually a movie about this case. I think it's called Little Pink House or something like that. It came out a few years ago. I haven't seen it. I have no idea if it's good. But that's what it pertained to. Kelo owned a little pink house that the government was trying to take so that they could build this new economic development project for the benefit of Pfizer. So, government and Pfizer have sort of been getting along for a while here. But anyway, this case ends up being heard. And the majority of the court, the majority opinion in that decision ends up saying that, yes, redeveloping this land is a legitimate is a legitimate public use of that land, which is, I won't give my opinion on whether or not that's consistent with the Fifth Amendment, but it certainly seems to be a long way away from the way the Fifth Amendment was originally interpreted. And this ends up causing an uproar across the nation, publicly speaking. Prior to the Kelo decision, I think there were maybe 7 states that had provisions saying that a state could not take land and then give it to another private party. After the Kelo decision, I believe there are now 45 states that have this requirement in their laws. California is one of those states. We implemented that law, I believe, in 2009, I think by ballot referendum, if I recall correctly. But now most states, they didn't like that. So as I mentioned, Fifth Amendment is the outermost limit of what a government can do, but governments are perfectly free to restrict their own powers in excess of what the Fifth Amendment allows, which many states have done, now saying they cannot confiscate property if they're only going to give it to another private person. So that's a good thing. I think that the court, when the court errs, sometimes the political process is able to step in and remedy that. But that's the current state of what takings law looks like. Boy, this is going to end up being a long one. What are we at? 33 minutes. I apologize for the length here. Hopefully I didn't ramble too much in this. In answer to the question, ultimate answer to the question of when is it appropriate for the government to take private property, it is appropriate if the property is taken for public use. And in my opinion, it is only appropriate if that property is taken by the state governments. I think, and this is sort of, The Bill of Rights is, I don't want to disparage the Bill of Rights for a second. It's one of the obviously most important and significant documents in our constitutional system. But in some ways, for subsequent courts, it's caused a bit of confusion. Because when the Fifth Amendment says, your right to take private property is limited to X, Y, Z, that implies they have a right to take private property. And that right just doesn't exist for the federal government. It's found nowhere in the Constitution. I think it's a huge stretch to apply the necessary and proper clause to it. So, that misunderstanding, I think, was sort of caused by the Fifth Amendment there. But it's not one that is impossible for us to remedy. And my hope is that videos like this would go a long way toward doing that, because making sure that people understand where their rights come from, and more importantly, or not at least equally importantly, is structurally how those rights work together. Bill of Rights doesn't create rights. Bill of Rights is a limitation making explicit rights that already exist under a constitutional framework, and that's very, very important to keep in mind when looking at issues that pertain to things that are in the first 10 amendments. So hopefully that answers your question. I guess I haven't really talked about what sorts of things I would believe constitute public use. Certainly transferring to a private party would not. I would say public use has to mean that it remains in government hands. It has to mean that it is being used for something that benefits the public at large. A kind of classic example of that is military installations, military bases. Obviously those are going to benefit the public because all of us have an interest in our country being defended from foreign aggressors. Whether or not we spend too much on that is a separate issue entirely, but certainly I think most of us would agree that they do have the power to do that. Although that could be done under the Enclaves Clause as well. You wouldn't even need to use takings for that. As far as state government takings, things like roads are legitimate. If you just can't get that one guy to sell so you can have a continuous road going from Los Angeles to San Francisco, or a bullet train that is never going to get built and going from Los Angeles to San Francisco, that would probably be within the legitimate authority of the state. Whether or not they should build that bullet train is a different issue. But they could seize land so they could build that train. That makes sense. That's for public use if they do that. Although I think they've actually transferred a lot of that to private parties. Certainly the train's operated by a private party. I would say if the train's being operated by a private party, that's an ambiguity. I think there's definitely a plausible argument that's not for public use. Even if government retains title to that land, I would certainly take that stance. Again, because of the direction in which the case law on this has evolved, I don't know that you even get to that question. There's not going to be any case law on that issue specifically because that's not the route things ended up going. But we're going to try to push them back that way. We're going to try to keep the government within its bounds that were originally conceived by the Constitution as envisioned in 1787. And if anybody watching this video has a case where you think that your property is being unjustly seized by either state or federal power, we can absolutely help you out in that. And we would love to take that case on your behalf and come alongside you, help defend your rights. Last issue I should address is what's called regulatory takings. So regulatory taking is when government doesn't actually assume title to somebody's land, but through a regulation deprives them of the use of that land for some kind of economically productive purpose. So, if you owned a cattle ranch somewhere and then a new zoning law was put in saying you can't have cattle ranches there anymore, you can only have, bed and breakfasts or something like that, and you don't run bed and breakfasts, so you've been deprived of the use of your land, that could be considered a regulatory taking. I'm not going to get into that today because that's a whole other issue with its own related concepts and issues that go along with that. But that covers the idea of takings and the idea of eminent domain, but I prefer we not use the term eminent domain when we refer to takings. Again, this has been a presentation of the Lex Rex Institute. If you enjoyed this presentation, I encourage you, please click the like icon on the video, or underneath the video. Click the bell icon to receive notifications. I'm told that I got that wrong on my last video when I talked about it. I still don't really know what that means, but go ahead and click those if you liked the video. If you feel so moved, we always encourage contributions. You can go on our website and make a contribution to the Lex Rex Institute. All of our contributions go directly to representing people whose rights have been abridged or rights have been denied on issues like the taking of private property. Thank you again for your time. My name is Alexander Haberbush, and this has been a presentation of the Lex Rex Institute.